Our next speaker for this session is Dr. Varsha Khandagale, a distinguished academician, legal expert, and our very own esteemed faculty member at ILS Law College. Dr. Varsha ma'am is an assistant professor at our law college and holds a PhD in law. She secured the second rank at Pune University in both LLB and LLM. She has over 12 years of teaching experience. Her areas of expertise include family laws, land laws, environmental law, contract law. Beyond academia, she plays a crucial role in legal training. She is a regularly invited trainer at ILS Center for Training for Good Governance, where she has trained over 400 town planning officers, 800 land record officers. She is also actively involved in designing training modules, materials, and assessment activities for these programs. Dr. Varsha ma'am's expertise extends to policy making and inclusive governance. She has been invited as a trainer at the Maharashtra State Faculty Development Academy to discuss inclusive policies in educational institutions. She also leads impactful social initiatives as the in charge of the project addressing gender-based discrimination and violence at ILS Law College in collaboration with SWISED, where she has contributed to the development of user manuals on child marriage and domestic violence. Additionally, she is a certified mediator with the ILS Center for Arbitration and Mediation, enhancing her role in conflict resolution. I now request Dr. Nilima ma'am to felicitate Dr. Varsha ma'am.
Good morning, all of you, especially Dr. Bhadbade ma'am, Advocate Tejas Vora, Advocate Srinivas Patwardhan, and all the participants of this seminar. So, as ma'am has given a nice setting to what representation means, some of my initial slides I would not be going into much details. I would be only covering that part which needs to be discussed in order to understand the rest of the part of it. So what I am going to talk about is only relating to the powers of executors and administrators, and certain questions which then arise out of the legal provisions which we can see from these sections. So as ma'am has already pointed out that the property is something which is expected to pass on to the legal heirs immediately. However, this is an English principle or English law principle that instead of giving it directly to the beneficiaries, there is a intermediary who comes in between in the form of a representative, and the entire rights of the deceased along with his liabilities are expected to first go to that representative, and then from the representative it will pass on to all those who are entitled to it. Now these persons who are entitled to it can be at certain points of time those persons to whom the dues are to be paid by the deceased. So at the time of his death, it is not necessary that the deceased dies without any debts. There are certain outgoings which he has to pay. So the representative will see to it that all the outgoings are paid. There is a possibility that the property of the deceased is in the hands of third persons. So the representative will also try to collect the property from all these third persons. So there is a proper inventory of what were the assets of the deceased at the time of his death, what are his outgoings. So this balancing will be done by the representative, and then whatever remains, he then will distribute it amongst the beneficiaries. Now when we are looking at here as the beneficiaries, we are including both the legal heirs in case if a person dies intestate, as well as legacies where the person dies by making a will. So this is something which is an English law principle which states that it will not directly vest in the beneficiary, but it first go to the representative who will do all these tasks, and then from there it goes to the beneficiaries. Now, this principle of English law is something which is also adopted in India in the form of certain provisions which are incorporated in the Indian Succession Act. So if you look at section 211 of the Indian Succession Act, it states that executors or administrators are the legal representatives of the deceased person. It does not stop here. It further says that the property of the deceased vests in the executors or administrators. Now this wording which is used in section 211, that the property vests in the executor or administrators, might at certain point of time be confused as to whether he becomes entitled to that property or whether he is only a representative and the property is vesting as a representative. So we have to understand that the words which are used in section 211 is property vests in the executor or an administrator as such. Now these words which are used as such has to be understood to be and has to be read along with representative of the deceased. So what is vesting in the executor or administrator is not the right to that property. The property does not belong to the executor or administrator, but it is merely a right to represent the estate of the deceased, and in the representative character the property is getting vested in him. Now, so this is something which we need to understand, and when we are, that is why section 211 can also be read along with section 1 of the Bombay Regulation Act 8 of 1827. Initial section 1 itself says that irrespective of whether you are taking any representation from the court or not, legal heirs are going to have a right to deal with the property. Okay, so we need to understand these two things. Section 211 says executor or administrator becomes representatives. Section 1 says heirs, executors or administrators are representatives automatically. So this brings us to the question as to who can be representatives, and we can find out by reading both these sections. We can find out that representative can be a person who has been appointed as an executor by the testator through his will. Representative can also be a person who is appointed as an administrator when there is a will made by the deceased. Now this administrator cannot be appointed or is generally not appointed by the testator but is appointed through the court. Even when a person, so this is what happens when a person dies testate. But if a person dies intestate, in such a case, who will be the representative? Because we do not have an executor as there is no will. And because there is no will, the administrator is also not appointed. But in that case, again, we can have an administrator being appointed when the person dies intestate. So we have to understand that administrator is possible to be appointed when a person dies testate as well as when a person dies intestate. Whereas executor is a person who will be appointed only when a person dies testate. Now with respect to a successions, so these are the two ones, that is a person who is an executor or an administrator, he becomes a representative. The third person who can act as a representative is a holder of a succession certificate. Now succession certificate is granted under section 370 of the Indian Succession Act, and as per the provisions of this, as per these provisions, a succession certificate can be granted only in respect of a debt or a security. So here the person, again, the deceased might be a testate or he might be an intestate, but with respect to only debts or securities, the holder of a succession certificate is going to act as a representative. He cannot act as a representative in other cases. The fourth one who can act as a representative is a person who holds heirship certificate, which is granted under the Bombay Regulation Act of 1827. Here there is no bar, and you can also have an heirship certificate granted to a person who is with respect to his movable as well as his immovable property. So these are the four types of representatives which are possible. Now for being a representative, is it necessary that you need to have a document? As ma'am has already told in whatever she has presented, that this document need not be mandatory in all the cases. So we have executors, we have administrators, we have holders of succession certificate and holders of heirship certificates as representatives. We need to find out whether they need to bring some document from the court to act as a representative. So here section 212 says कि if at all the person has died intestate, then such letter of administration will not be mandatory in case of Hindus, Mohammedans, Buddhists, Sikhs, Jains, Indian Christians and Parsis. So you will find that most of the communities which are present in India are excluded from the provisions of this particular section. So when a person dies intestate, there need not be a letter of administration which needs to be taken mandatorily. Then who will act as a representative and on what basis? Here, as per section 1 of the Bombay Regulation Act of 1827, any beneficiary that is an heir can act as a legal representative without there being a heirship certificate or without there being a letter of administration. So directly being a beneficiary, they are going to get a right to act as a representative. However, if there is a will made, then is representation mandatory? With respect to a will, we have to understand that there are two possibilities. One, where there is an executor appointed by the will, and second, when there is no executor appointed by the will. If there is an executor appointed by the will, the executor gets his power directly from the will and not through the court's order. And that is why for an executor, again, it need not be necessary that he goes to the court and obtains representation. However, this representation is still mandatory in certain cases. So we have to get a probate if at all the deceased has made his will within the jurisdiction of the local limits of a High Court of Madras, Calcutta or Mumbai. So because we are dealing, if we concentrate on the state of Maharashtra, if he makes a will within Mumbai, then it is mandatory for that deceased person to for the representative, that is an executor, to obtain a probate. Second important condition is if he makes a will anywhere else, but if it relates to an immovable property which is situated in those regions, then again such probate becomes mandatory. Now coming to the letter of administration. Letter of administration, when there is a will, is necessary if at all certain rights are to be claimed through the court, and administrator is not appointed by the will, and that is why unless and until he is appointed through the court, he will not get a right to act as an administrator. That is why letter of administration becomes necessary when there is no executor, provided certain tasks are to be done as an administrator. Okay, again this is mandatory. Mandatory hai kya? So it is mandatory only when it is situated within those regions or the will is made within the regions which we have talked about. So this tells us about whether it is mandatory or not. Section 214 is what where ma'am actually stopped with her session. That is it necessary to obtain a representation if at all we need to collect certain debts from the debtor. In such a case, 214 says that it is not mandatory unless and until you have to approach a court. So it says that the court shall not pass a decree. Okay, so even there are judgments which might say that you can institute a suit without being appointed as an executor or an administrator through the court, but the court cannot pass a decree unless and until there is a such kind of an administration document or representation document which is produced. Now next important question which comes up is, from when are these representatives entitled to act? So before we go to what are their powers, we need to find out from when their powers will begin. So with respect to executor or an administrator, there are two specific sections. Executor, section 227, it states that the executor acts as an executor not from the time when he obtains a probate, but he can act as an executor from the death of the deceased, because he has been appointed as an executor through the will. Secondly, if at all there is a time gap between he acting as an executor and he getting a probate from the court, then all the intermediate acts which he does in between are always validated whenever ultimately the probate is granted. So even where the probate is mandatory, he need not stop till the probate is granted by the court. He can immediately start acting, because the granting of probate will always relate back to the date from which it is granted. Coming to the letter of administration, section 220 and 221 deals with it, and it says that whenever it is granted, doctrine of relation back applies. That is, it will always relate back from the date of death of the testator, and that is why even if it is obtained later, it starts operating from the death. But here there is an important difference which you find between an executor's powers and an administrator's powers. It says that in between, if there is a time gap, that is from the death till the grant of the letter of administration, if the administrator does some acts and those acts are injurious to the property of the deceased, then they will not be validated. So only those acts which are beneficial to the property of the deceased will be validated. Now this restriction does not actually apply to an executor's powers. So we have to understand that executor also can act from the death of the deceased. Administrator ideally has to act from the grant, but if he acts from the death of the deceased, that acts can still be validated provided it is proved that they are beneficial to the deceased. So this tells us from when an executor or an administrator can start exercising his powers. Now let us come to what are the powers. Now these are few important powers which an executor or an administrator enjoy. First of all, he has a power to sue. Secondly, he has a power to dispose of the property. Thirdly, we find that he has a power in certain cases to purchase the property, but this has to be used very cautiously, because this purchase can be declared as voidable by the court as well. Fourth is, he has general powers of administration, means because the property is vested in the deceased, he will be looking after the property, taking care of the property, doing repairs. All of these rights he is going to have. Along with that, he is also given certain powers with respect to legacies. So let us come to power with respect to suing. There are two sections in the Indian Succession Act, section 305 and 306, which talks about what do we mean by what kind of power the executor or an administrator enjoy with respect to filing a suit. So section 305 says that any cause of action which exists even after the death of the deceased, with respect to all those causes of action, the executor or an administrator can sue or be sued. So wherever the rule of actio personalis moritur cum persona, that is, with the person dies the action, this does not apply. In all those cases, the executor or an administrator, that is the representative, has a right to sue or be sued. Now, along with this, you will also find that 306 says that there is a power with the executor and an administrator to prosecute or defend any action. There are certain exceptions which are given. Exceptions are defamatory suits, suits with defamatory actions, or rather actions with respect to assaults, and actions with respect to personal injuries which does not result into death. With respect to these three kinds of actions, there cannot be any representation which can happen, and there cannot be defending or prosecution which can happen through the representatives. Rest all the actions are possible to be taken up and defended by a representative. Now section 216 is also important, because it says that once a probate or a letter of administration is granted, it is only the executor or an administrator who has to sue or be sued. So you cannot sue unless and until the executor is filing a suit or the administrator is filing a suit, provided this kind of a grant is made by the court. Now if the grant is not made, then can someone else apply, and can someone else act as a representative in a suit? we will also have to look at the provisions of the Civil Procedure Code, wherein a legal representative can file a suit or can also defend a suit. So it is not that only Indian Succession Act provisions have to be taken into consideration. This is a power given to the executor or an administrator and is expected to be used by them, especially mandatorily when the grant is made. But when the grant is not made, even the beneficiaries are allowed to file a suit. That is what is my understanding. Definitely the resource persons can further add on to this. Now, second important power which the executors or administrators get is with respect to disposing of the property. Section 307 deals with it. Now, very important, because let's take an example that a property is bequeathed by a will to A. So, the testator intends that this property should be given to A. However, the executor sells it off. Now, whether the sale should be valid, because as per his intention, it should have been given to A, but the executor, instead of giving it to A, has sold it. Now, the section says that such kind of sale is allowed, and it is not only allowed, it is valid. Now, we have to understand why such sale is allowed, because representation means he is in charge of paying all the debts, paying all the other legacies also which have a priority. So there is a possibility that when the deceased died, there were lot of outgoings which the deceased had, and that is why he needs to have a right to sell the property, take up the proceeds, and using those proceeds he will then have to, only after paying off all the debts, he can proceed to paying off the legacies, and that is why such power of disposal has been given. However, the power of disposal which is available with the executors and the administrators differs as per the religion. You will find if the deceased was a European, if he was a Parsi, if he was an Indian Christian, then in all such cases, executor or an administrator has an absolute power to dispose of movable and immovable property, and in such cases, alienee acquires a good title to that property. However, with respect to Hindus, Mohammedans, Sikhs, Buddhists and Jains, the executor again has an power of disposal unless and until it is restricted by the will. So, if there are restrictions contained in the will that the executor cannot sell or executor cannot mortgage, it is only in those cases that this power will not be available. But when there are no such restrictions, executor can proceed for the disposal of the property. Even when there are restrictions, it does not mean that the executor cannot dispose. He can still dispose of the property with the court's permission. So, that power is there with the executor with respect to the religions. Now, coming to the administrator, however, there are restrictions. With respect to administrator, it is prescribed that administrator cannot dispose of the property unless and until he obtains the permission of the court, and this disposal includes sale, mortgage, gift, exchange, and also leasing the property for more than 5 years. So, if a lease is to be done for less than 5 years, permission of court is not required, but in all the other cases, the court's permission is mandatory. So, you will find that there is a difference between the power of an executor and that of an administrator when it comes to disposal of the property. Now, when this property is disposed of, we have to understand what rights the purchaser gets. The purchaser or the alienee, not necessarily it is going to be a sale, it can be a mortgage, it can be a lease. So, whosoever is the transferee of that property, he is going to get a good title unless and until the alienee or the transferee has a notice that the executor or administrator was acting fraudulently. So, when there is a notice of fraud, whether actual or a constructive notice of fraud, in only those cases the transferee's title is affected. In all the other cases, it is going to be protected. Now, so this is what we have already seen. It is allowed to be done. So when the power of disposal is given, is it an completely unrestricted power, or there are certain restrictions on it, or can it come to an end? Now this power of disposal has to be used only for the purposes of representation. It cannot be misused. It cannot be used when there was no requirement for the purpose of administration to dispose of the property. So it has to be shown that there were debts which were outgoing, there were certain legacies which had preference and which had to be paid, and that is why such kind of disposal is done. If this disposal is not proven, or this representation requirement is not proven, then the disposal can be set aside. Along with that, it is only for representative purposes. So when representation comes to an end, the power of disposal also comes to an end. It cannot exceed forever. The executor or an administrator also has a power to incur expenditure. So all the lawful expenses, some litigation expenses, expenses with respect to taking care and management of the property. He can also incur expenses towards religious or charitable purposes, but for that he needs permission of the court. He can also undertake expenses towards improvements of the property. So there is a difference between regular updating of or upkeep of the property and certain major improvements. If improvements are to be carried out, the executor or administrator will need the permission of the court. However, if the deceased was carrying on a business, it is prescribed that there is no power through the court's judgments. It is specified that the executor or administrator will not have a power to continue the business unless and until that is a specific intention which is prescribed by the deceased. Now when it comes to power to purchase the property, now the executor or an administrator can purchase the property of the deceased, but you have to also keep in mind what section 310 says. It says that if such purchase is done, it is voidable at the option of any person who is interested in that property. So a creditor maybe with whom the property was mortgaged, maybe a person or a legatee to whom the property is given through a will. So these are the persons who are interested in the property, and that is why they can challenge this kind of an alienation. So it has to be understood that if executor or administrator himself is purchasing the property, it can be later on challenged by the interested parties, and this kind of a restriction does not have any exemption on the ground that the sale was done with the permission of the court. So even if it is done with the permission of the court, it can later on be set aside. Now again, this is an important part, that is with respect to legacies. Section 325 says that legacies cannot be paid unless and until the debts are paid. However, further it is also prescribed that whenever section 332 states that in order to confirm the title of the legatee, it is necessary that the executor or the administrator should give his assent. So only when he gives his consent, then the legatees are going to acquire a title. So the title will not get completed unless and until executor or administrator gives the assent. So what is the position when the assent is not given? Does it mean that the legatees then are not going to have any right at all? The position taken by law is it is an inchoate right, and that is why the legatees also can simultaneously deal with their property. They can also assign their property, and however, if they have taken up the possession of the property without taking the consent of the executor or an administrator, then action for trespass will lie. So there is a need to balance both these things. On one hand, we find that assent of executor or administrator is made mandatory. On the other hand, it is also stated that legatees' rights continue. Though they are inchoate in nature, they still continue, and they are also allowed to assign these rights further. But if they assign it, there can be actions taken, and that alienation can also be avoided by the other interested parties. Now, these powers are certain other powers which we find that they can receive commission or agency charges, but there are limits which are prescribed in section 309. when there are more than one executor or administrators appointed, one of them or some of them can also act unless and until there is a contrary direction to that effect. This is what are his duties, and this is what the sequence which has to be followed. First pay the funeral expenses, then pay the deathbed charges, then pay medical attendance, then boarding and lodging for last 1 month, probate and letter of administration expenses, then wages for last 3 months, then debts, then legacies. Again legacies in this order, first specific, then demonstrative, then the general. Now along with this, the executor or administrators are required to act fairly. So section 368 and 369 states that if at all through their actions there is any loss caused to the estate of the deceased, there is misapplication or there is negligence done by the executor or administrator, then they will be liable for such activities, and they are called as devastative. Now, with respect to succession certificates and heirship certificates, however, we find a little bit different provision. What does it states? The holder of a succession certificate has a right to collect a debt or a security. Secondly, what right they have is they can receive interest or dividends on it. And thirdly, they can also have a right to transfer or negotiate the securities. Now, do they have all the other rights which are available to an executor or an administrator? That is something which we need to ponder upon, because the wordings which are used by the executors or administrators when the powers are given to them and to the holders of succession certificate are comparatively different. However, it needs to be understood that this holder of a succession certificate also does not have any title to the property, and he only holds the property on behalf of the beneficiaries. If the beneficiaries claim it, again he will have to pay it to them. And with respect to heirship certificates, there is section 7 who says that a holder of an heirship certificate can do all those acts and grant all those deeds which are competent for a legal heir, executor or an administrator. He also has a right to sue. He also can obtain a judgment in that capacity. He is entitled to legal management. However, it is not a document which gives right to the property and is accountable for all the acts in that capacity for all persons who has actually a right and are entitled to that property. So this brings us to the last part, that is what are our concerns. So what we find here is there is always going to be a tussle between the rights of representatives versus the rights of beneficiaries, because whenever the rights of representatives are there, they have a right of disposal of the property, they have a right to give assent to the legacies, but on the other hand the rights of beneficiaries are also protected. So how do we understand this clash or conflict of interests which is created? Secondly, what precautions must be taken by the courts when while granting such certificates, whether it is necessary that the court should find out whether the executor is also fit or competent to act. Should the probate be made mandatory in such cases where the executor which is appointed has later on become incompetent, or can we then also say that executor, because he is appointed by the will, can start acting right from the death of the deceased? So again, with respect to succession certificate, heirship certificates, to whom it has to be granted, whether the court has to look as to what is the succession law which is applicable, who is the heir, if there are more than one heirs, do they have to decide what are their shares when the certificate is granted? These are also certain concerns which needs to be considered. Is there a need for a provision in the Indian Succession Act for granting of a document like an heirship certificate, because succession certificate is limited only for debts and securities? In case of intestates, letter of administration is not mandatory. For wills, there can be a letter of administration or there can be a probate, again not mandatory in all cases. So if I want to get myself confirm that I am an heir, what kind of document I go to if I have a movable or some other property which does not fit into debt or a security, and I don't want to get myself appointed as an administrator or as a executor also. So there is no provision except for the Bombay region. That is why should we think of having such kind of a provision there. And many a times such kind of production of a document is made mandatory, as ma'am stated in her address also, that some minor amounts can be paid on the basis of indemnity bond, but can it be made mandatory, or should it be made mandatory, or the present position itself should be continued? And lastly, we have so many certificates creating so many different rights. Is there a need that there should be a unified approach which can be formulated, where irrespective of the religion of the parties, irrespective of testate or intestate, some kind of a simplified process is prescribed with respect to representation as well as claiming the rights of beneficiaries? With this, I would like to end my session. Thank you.
Thank you, ma'am, for sharing your valuable insights. The dais is now open for question and answer round. If anybody has any question, you can ask Varsha ma'am and Nilima ma'am.
If no, then because already the time is over, so we can go for a tea break, and then we can again come back, because then we have to also start with the other sessions. Yes.